qualify as harassment. But there are some forms of behavior which are egregious. They only need to occur once. So, for instance, grabbing somebody's crotch is grossly offensive. You don't need to do this on a repeated basis before somebody recognizes that that is harassment. So I think one of the ways we can think about it is there's a repeated transgression of somebody's boundaries. You said no, or you've tried to communicate no, or you have indicated a reluctance and an unwillingness, and that keeps on being ignored.
Just a little bit slower so
Sure.
that everyone can take notes. So there must be repeated transgression of somebody's boundaries.
Yes. So saying no or indicating that something is unwanted or showing that you are reluctant and that you are unwilling. And I think what the code recognizes is that in an ideal world, when that happens, we'd all be able to say, no, stop that right now. This makes me uncomfortable. Please do not do that again. But the code does recognize that that's not always possible. It talks about, for instance, you can just walk away or not respond. And much of the literature, much of the legislation looks at the fact that one of the reasons why sexual harassment occurs and why it is so difficult to deal with is because of power imbalances. And that is where one has to look at these very carefully in order to consider, was somebody genuinely in a position to say no? Could they clearly communicate how they felt about the situation? Could they tell somebody to stop? And we can see in law that those kinds of situations do occur. And if we look at rape, for instance, there is quite a clear recognition that there is a difference between submission and consent. That one can say yes, because saying yes might be the less worse of two terrible choices. And that if and that's submitting, that for consent to be meaningful, it has to be genuinely given. Otherwise, it is simply superficial. So there has to be a substantive, meaningful sense undergirding a consent. It's not meaningful to say, oh, you consented if your child is in the room at the time and you are being raped. Saying yes does not mean you were consenting, you are submitting because of what is going on. So I'm using the example of rape, but law has recognized that there are occasions where it may look like you are agreeing to something, but it's not meaningful agreement. So, and I think there's also increasingly a recognition that consent to one thing doesn't imply consent to any behavior that follows. So wearing a short skirt and accepting a drink does not mean you have consented to any other behavior beyond that, for instance.
Sorry, I didn't understand the previous point you made.
Which one?
The point just before that one. You're talking about as if the consent may not look genuine, or may look this way but may not be genuine, or something to that effect.
Yes.
Just explain that.
Sure. So I'll use a very blunt example. If somebody says, the one example is, if you don't have sex with me, I'm going to beat you to a pulp. Well, all right, yes, I'll have sex with you. Or the other example, which you've seen in law, is somebody breaks in, they are about to assault you, you say, okay, no, hold on, I'll cooperate. Can you wear a condom? They put on the condom, rape, and then leave. We have had cases where the law has recognized that you saying to that person, okay, I'll cooperate if you stop beating me and wearing a condom, that did not mean you consent to what happened. What you tried to do was, you had the option, there was no way you were not going to escape being raped. All that was within control at that point in time was whether or not you were going to also be beaten very, very badly and possibly end up with a sexually transmitted infection as well. So the courts have understood that under some circumstances you have very constrained choice. It is very restricted. You have very few options. You try to exercise what agency you can within a very limited context of choice. That where that context and those constraints are so limited, you can't genuinely call that consent. That is submission.
In your summary that you provided to us also, under the method employed to arrive at your opinion, you indicated that for biological reasons, women and men's expressions and experience of their sexuality are not the same. Can you explain that to us as well?
Certainly. So I think one of the things one also has to take into account is that we have a history of thinking that, well, men have these explosive, uncontrollable sexual urges that once aroused, they cannot be stopped. And I mean, this is what some of the mythology that has informed and excused rape, for example. Oh, she had on a short skirt and I was so overcome and she'd allowed me to fondle and kiss her and I was just so overcome with my feelings that there was nothing I could do except continue. And that's been referenced as kind of biological, explosive idea of male sexuality, that it is basically uncontrollable. Once you arouse it, it cannot be stopped. I mean, that is not correct. But it is a myth that can function as an excuse for rape. And I think we have worked in many ways to understand that men are certainly well able to control themselves, and that we cannot allow that kind of mythology that has arisen and developed to allow sexual violence and abuse to continue. So I think when you look at cases that involve sexual harassment and sexual abuse, it is important to understand whether or not there is any recourse to myths and stereotypes in order to explain conduct. And whether or not that's allowing thinking to be clouded, whether or not when you're trying to assess behavior, whether you're trying to look at what is here presented to you and to what extent your thinking about that is perhaps clouded by other ideas or ways of trying to explain what you've seen. And I've said one of those which is often clouded thinking has been this idea that men and women have vastly different sexual urges. Men's are much more urgent than women's. And I think the other idea that has developed from that is that men pursue, and it's up to women to say yes or resist. So we live in a society that has granted men a much more active sexuality and women a far more passive sexuality. They wait for men to approach them. They do not go out to the first man they see and say how fabulous he looks in that pair of tight pants and when can they get together. Society would think that a little strange, whereas we accept the idea that if a man will go up to a woman, you look fantastic, whatever. So we have created a society that does treat men's and women's sexuality very differently. I mean, as a very common example, if we talk about sexuality, is that, take the word whore. It's very hard, it's a word we use for women. It's very hard to find an equivalent for a man who we consider to be overly sexual in an insulting way. We might call him a stud, for instance, but that's admiring and speak of his virility. But when we talk about women who are very sexually active, we tend to use very derogatory terms like whore. So I give that as examples of the way in which society has constructed quite different ways of thinking about men's and women's sexuality, in which active sexuality in women tends to be frowned on, whereas active sexuality in men is recognized, acknowledged, and even admired. And I think that is what can also make sexual harassment quite difficult, is that men will persist and persist and persist, saying, oh, but, women just they just need a little bit of persuasion. I just need to work a little bit harder. Or the other myth, women say no when they mean yes, and women play hard to get. Those kinds of stereotypes that I think get in the way and make it difficult to deal with harassment.
Thank you. If we go to 2.1.2 in your summary, that is the, where you say that in the case of sexual harassment, these gender relations of power can become complexly intertwined. Can you explain that for us slowly?
Sure. So we have, I think, already what we can call gendered power relations that tend to structure relations between men and women in a particular way. I've outlined some of those. Men advance, propose, women accept whatever. So you've already got that kind of relationship. And I think it's also a power relationship in the sense that, there are many examples of it. The Constitution has tried to address it. We speak often of gender inequality, which manifests in a range of ways. Workplace is one, in that you will find who performs what work. And this is precisely why we have things like employment equity and affirmative action in order to address this. Who does what work is very gendered. So if you walk into a garage, for example, you will find that most mechanics are men. It will be unusual to find women mechanics. If you walk into an office and you look at who are the secretaries, they will predominantly be the women. If you look at who are the CEOs and the senior managers, they will predominantly be men. So you have that kind of structuring in terms of who holds positions, who is likely to hold what position, and what kind of qualities we associate with women's positions. So a secretary is often there to serve, to make coffee, to make tea. I'm speaking now obviously in very general terms. Is supposed to be doing the service side. Women are more typically, or anybody else who's in a subordinate position, there to listen and to carry out instructions. So you have that kind of, you bring in the gendered social relations, and then you see how gendered relations also inform workplace structures. Then workplaces obviously have their own sets of hierarchies. In order for people to do their work, clearly those who are in positions of authority need to be able to have the authority to be able to instruct, in order to be able to ask people to do work. And if people do not do work, to take the necessary steps to ensure that they do the work. So we have these complex, in terms of labor law, what do you do in terms of disciplining, instructing, the consequences of not performing, etc. So you have those who can instruct and who can't instruct. Hence your ideas about insubordination, because you are not obeying instructions, for example. So workplaces are quite clearly structured they are hierarchical, because you need to have that kind of relationship, and they are more or less hierarchical. Some are extremely hierarchical. If you look at the police, for example, that is command and control. It is instruction, the same with the military. But you wouldn't quite find that kind of degree of control in your everyday workplace, for instance. But nonetheless, there is still an authority structure because of the nature of work and what needs to be done. So you have those kinds of relationships, and it's why we have workplace law, is to be able to set out who is overstepping their authority, who is disregarding authority. So, and with that, you also have your things like your job descriptions in order to set out who is required to do what, so that, again, we can get into these questions of, I can instruct you to do this because your job is required, this is your job, or I don't have to do this because this is not part of my job. So workplaces, different industries have different norms, but they are very structured in terms of how do you work, who does what, who says what, who listens, who obeys, what are the sanctions. So that is why it can become quite complicated once you're dealing with sexual harassment, because saying no to somebody who is your senior is difficult. Firstly, it is an inversion of the relationship as to who directs or instructs, and who follows instructions. So for a junior person to tell a senior person, it can be a very difficult thing to do precisely because there is that inversion. The other thing is, what are the consequences of me saying no to somebody who holds a higher position in the hierarchy than I do? If I say no, I am their junior, will they take me seriously? And what are the consequences? Can this person victimize me? Can they make my work uncomfortable? Can they ask me to go and start doing work that I don't want to do? Can they start taking away workplace opportunities from me? Can they start speaking to me in a way that is extremely uncomfortable and makes my work miserable? So this is where it starts to get uncomfortable because you now have not just the operation of the informal social relationship of gender, but you now have a structured relationship upheld by law that sets out this is how you will relate to each other, this is a workplace, this is who says this, and who does this, and who does that. So that is why it becomes very difficult. But I think one must also think in relation to sexual harassment and power relations. You have your structured relations and what we would call formal power. So formal power will obviously be where you have your organogram. It's formalized. This is your position, this is your position, this is what you do, this is what you do. It's set out, it's formalized. But then I think when you look at sexual harassment between peers, it's important to realize that power is very much more complex than just a question of position.
But in this instance, we are working with different power relations. There's a vast difference between the judge president and the judge's secretary. Is that correct?
Very definitely. And I think there is also a situation here where, obviously, if you're talking about power, there are layers of power. So you can talk about someone's immediate line manager. That's the person who has direct control over them. So in this case, as I understand it, Judge Mbenenge would not have been the line manager, and courts, as I understand them, and I stand to be corrected, don't quite have that kind of arrangement. You have a judge who's not necessarily somebody's line manager, but nonetheless, the secretary works or is not necessarily directly employed by the judge, but that's who they work for. That's who they take their instruction from, and they work for that person. So you have multiple, from what I can see of the courts, they have multiple layers of hierarchy. So you have your judge, who you may be immediately working for, but then you have somebody who's at the apex, a judge president, who is responsible not just for that particular court, but for the entire province. So it's a little bit like, in a company, you have your line manager, and then there's the CEO. The CEO might not be your direct line manager, but you still would not be rude to the CEO. That person is the most senior person. So I think this is where it's important to think about other dimensions of power beyond just the formal that I spoke to you about. There's also the questions of influence. So even if somebody doesn't directly manage you, they can influence, again, you can see this university, they can influence your career progression. If that person carries a lot of status and credibility, and I think this is the other important thing to look at, is how position confers other aspects of power, which include things like status and credibility. Who is more likely to be believed? Who has the higher status? Who will be seen as being more credible? Whose word will carry more weight? Even if you have influence, if somebody, I'll use a university example. You might not be employed by that particular person, but that lecturer or that faculty head can tell others in other universities, even if they just need to say something like, because people will say, well, can you recommend that person? What do they like to work with? I would be very careful. They don't work so well. You're not necessarily giving somebody a formal reference, but you have influence. People come and ask you, what do you think? And your opinion will count and hold weight. So one can also exercise that kind of power and influence, so that even if you've never said anything, you can still have an effect on somebody's career and their career progression. The classic example, if we're going to use legal examples, is the candidate attorney. They're not employed by the law firm, But if they lay, and when I've seen cases like this, if they lay a charge of sexual harassment, those are all senior lawyers who can make their progression and their lives and their careers going forward quite difficult, just because of what they can say and the kind of influence, clout, and weight that they have. So I think it's also important to look at those dimensions of power in addition to having formal positional power.
You mentioned the Code of Good Conduct, the 2022 Code of Good Practice, on the prevention and elimination of harassment. Where did this code come from? What was the starting point for this code? It derived from? Isn't it the Employment Equity Act?
Yes, and it's actually the early code of 1998, when it was called the Code of Good Practice on the Handling of Sexual Harassment. And then it was broadened and widened. And this code has also been influenced to some extent, I think, by the International Labour Organization.
All right. Now, in 2.4 in your summary, you also said that this code also offers some guidance on how conduct may be assessed as unwanted, recognizing that non-consent does not only take form of the stated no. You did mention it a little earlier, but just explain that again to us.
Okay, so I think, as I said, in an ideal world, we would all be able to communicate exactly what we want, need, and mean under all circumstances. But it's recognized that that's not always possible. And also, I think that people can be confused and not always know what to do initially. So it's recognized that you can communicate no in different ways. One of these would be to simply stay silent or to walk away. Or it could also include things like going to somebody else and asking them to intervene on your behalf, to have a word in somebody's ear, for instance. You can deal. There is a recognition that there are different ways in which this can be communicated.
So do I understand you correctly? The code says you do not have to say no using the words no. You can use these other tactics also to convey your correct message as being no.
Yes, and the code also recognizes that because you've previously consented in one thing doesn't mean you've given consent in perpetuity. You are required to check if your behavior continues, if behavior continues to be wanted. I mean, I think it's following broader trends that we're seeing, for instance, in two cases. The one was the Embrace Dignity matter, for instance, where the idea is that consent now we have to look at consent differently. We can't just rely on subjective perception. You actually have to think about, is it reasonable? I mean, the laws also, as I said, had this recognition of coercive circumstances. In relation to rape, for example, it recognizes that there are situations, and it's going back to this point of submission, and one of the points it looks at is where there is an abuse of power or authority. That again, somebody can abuse their position, and this is why you are submitting and appearing to say yes. But this force of abuse or this power and authority is making it hard for you to say no because you're not in equal positions. So I think there is a recognition that that when you look at consent, you actually have to look at the context. What are the circumstances under which somebody is saying yes or no or not saying anything at all? Are there circumstances that enable somebody to speak clearly, to be firm, to state their expressed desires, preferences, and needs?
Just explain to us, how does the concept of coercive circumstances help us understand consent in contexts where power imbalances are present?
Well, you have this in the Sexual Offences Act, that there is an abuse of power or authority. So coercive circumstances help us understand that it's hard for somebody to say no because of the authority that the other person wields. That person's, them saying no, that person is in a position where they can make life very, very unpleasant. So coercive circumstances you can think about as the recognition that it is a so-called choice in a context of no choice or constrained choice. So coercive circumstances are saying to us, look at the context. Yes or no doesn't occur in a vacuum. Look at what's going on around that person. What are the pressures on them? Have they given meaningful consent? I mean, we look at context, for example, to use another example, in medicine. You can't consent to a medical examination if you're drunk or high, for example. So we are looking at context. Is that person in a position to be able to say yes? What is the nature of their yes?
And how do you approach the interpretation of WhatsApp messages in the context of harassment? Do you look at them individually or in relation to one another? Just explain to us.
Sure. So again, I think one has to look at them contextually. So what has been the previous conversation, for instance, because I think one of the things one must think about in relation to people's interactions with each other is that they're dynamic. They're not fixed in stone. They change. So within the context of say, sexual harassment, you look at how, especially if it's a situation that is ongoing, you look at how is the nature of the engagement changing? Because typically, in situations where people have to work together, for example, you can see that somebody is grappling with, how do I deal with this situation? And so they try a range of different tactics and strategies to try to figure out what is the best way I can deal with this. Especially if they can't, and especially if they don't necessarily initially have the confidence or believe that they can say no. They may try different kinds of things. So you can find, for instance, somebody will say, I'll just ignore it. Because if I ignore it, hopefully it will go away. Or if I ignore it, they'll get the message to leave me alone. And then you might see over time that ignoring it is not working. This person doesn't leave you alone. They persist. So then you try something else. Maybe you try and start figuring out, okay, you figure out what are their workplace habits, where are they usually likely to be. You avoid meetings where they're likely to be. So you use a strategy of avoidance in the hope that you won't bump into them. Maybe this person still finds ways to bump into you. So then you try and make sure that you're always with another person so that they can't have that time alone with you. So you look at what is it that somebody is doing to try to manage the situation. And you can sometimes see a progression where somebody gets perhaps progressively more and more annoyed by what's going on, and then eventually they might become quite rude and get to the point where they say to somebody, just stop this. Or they will actually go to their line manager, if it's somebody they're working with, and say, I need a transfer, I need to go somewhere else. So it's important to look at what is going on here. What are the different things that somebody is doing? Not only that, these are interactions, they're engagements. So if she does this, how does he respond? What is her response to his response? What is his response to her response? So you try to get a sense of what's happening here. What are the strategies and tactics? Because I mean, if I could sum it up, looking at this, for somebody who's in this position, the question facing them is like, what are the strategies that are available to me to resist sexual attention from somebody who holds both institutional and moral authority? Somebody who's both an apex judge and a respected church elder, for example, without risking reputational harm or career consequences, and I'm a junior employee. So what's my room to maneuver? What can I do here? And so you'll see different strategies being tested out to see what works, what stops this person. And I said, sometimes you'll see a whole lot of this happening before somebody gets to a point where they'll actually go and lay a grievance. Because they've also realized the situation is now becoming intolerable. Because initially you can see with some women there's a sense of, all right, I'll just ignore it. It's not so bad. Actually, after a while, when it's repeated, it is that bad. So this is, you can't just look at separate, discrete, isolated units of conversation detached from each other. You have to look at how do they build and interact. Plus, you need to look at patterns. What is the pattern of engagement here?
Chair, I see it's 11 o'clock. Can we continue or should we break for tea at this stage? Because I'm going to move now to her findings.
We'll adjourn for 15 minutes.